So friends, Donald Trump's and Pam Bondi's and Lindsey Halligan's vindictive prosecution of former FBI Director James Comey ain't going so good for prosecutors. I mean, listen to these two headlines back to back on 2 consecutive days, yesterday and today. Judge demands to see more evidence on prosecutor Lindsey Halligan's handling of Comey case, and judge in Comey case scolds prosecutors as he orders them to produce records from probe. And friends, even at this early stage in the prosecution, the smart money is riding on the Comey case failing spectacularly. As I just discussed with my friend and fellow former career prosecutor, KEVIN FLYNN, in today's episode of The Prosecutor's Verdict.
All right, welcome everybody to another episode of The Prosecutor's Verdict. It is a recurring segment. You might say to yourself, well, wait a minute, Glenn, prosecutors don't render verdicts, to which I would respond, you're right. Typically, juries render verdicts, judges render verdicts if it happens to be a bench trial, a trial conducted by a judge. But given where we are, the lawlessness of the current leadership of the Department of Justice, these two old prosecutors are going to render verdicts on what we're seeing out of Pam Bondi and Lindsey Halligan, and really the person who has anointed himself the top prosecutor nationwide, and that would be Donald Trump. So we are rendering verdicts, mock verdicts, on what we are seeing unfold on the legal landscape. So first of all, welcome back, Kevin. As you've heard me say before, Kevin is a 35-year federal prosecutor at the D.C. U.S. Attorney's Office. Got me by 5 years. I did 30 years as a federal prosecutor. And I'm always thrilled to have him available to jump on with me because, you know, we have a combined 65 years of prosecutorial experience, including countless hours presenting cases before grand juries. And that's one of the issues that is front and center in both the Comey vindictive prosecution and the Letitia James vindictive prosecution. So, Kevin, welcome back.
Thanks a lot, Glenn. Great to be here.
All right. So let's talk about what has unfolded in really the last 24 to 48 hours. First of all, we'll give everybody a little bit of the backdrop. Lindsey Halligan, one of Donald Trump's former White House aides and an insurance lawyer with no prosecutorial experience, was installed as an interim U.S. attorney at the Eastern District of Virginia U.S. Attorney's Office, really expressly, given something Donald posted, to indict James Comey, to indict Letitia James. These are Donald Trump's perceived enemies, his foes, his critics. And so within about a day or two of being put in that position, U.S. attorney, Lindsey Halligan walked into the grand jury all by herself and did Lord knows what, and had the grand jury indict James Comey for allegedly making false statements to Congress and obstructing a congressional hearing, and indicted Letitia James for alleged mortgage fraud down in Norfolk, Virginia. And now we are in the midst of a legal battle in those two cases because both James Comey's lawyers and Letitia James's lawyers have filed motions to dismiss based on, among other things, an allegation that Lindsey Halligan is not a lawfully appointed U.S. attorney. We're going to set that issue aside on the merits right now, and that she may have abused the grand jury process in any number of ways. And that is kind of what brings us to the first issue that Kevin and I are going to take on. And it is, there's a judge who sits in South Carolina, Judge Curry, and he has actually been designated to litigate the Lindsey Halligan related motions because he's not part of the criminal justice system in the Eastern District of Virginia. He's an outside judge. So they brought him in. And next week, on the 13th of November at 10 a.m., down in the federal courthouse in Alexandria, he is going to sit and hear the motions for both James Comey and Letitia James regarding their challenges to Lindsey Halligan, and whether her appointment was lawful or not, whether she abused the grand jury or not. So, Kevin, why don't you bring everybody up to speed on the order that Judge Curry issued yesterday, and I will read the headline and then I'll throw it to you. The headline is this is Judge Curry, demands to see more evidence on prosecutor Lindsey Halligan's handling of the Comey case. So can you bring us up to speed on what that order was about?
Sure. I think the best way to come at this is to talk generally about the process and the way it should happen and it should be conducted as opposed to how it seems to have been conducted here. So anytime a prosecutor goes into a grand jury, there is a record made of those proceedings. Now, when witnesses are testifying, there is a court reporter who is in the room and is transcribing everything that the witness says. And those witnesses, if a witness is going to be testifying at a trial for the prosecution, it's up to the government to preserve those transcripts of the witness and to turn those transcripts over as what's called Jenks material. It's a technical term for the obligation that actually both sides have in a criminal case to turn over previously recorded statements of their witnesses to the other side. And this is incumbent on the government in a case where they've had a witness go into the grand jury and testify, and they have a transcript of that witness's testimony. Now, at the same time, though, everything that the prosecutor says to the grand jury by way of explaining the case, opening up the grand jury is the term that we use, explaining the evidence in advance that the grand jury is going to be hearing, and then afterwards, after the evidence has all been presented, asking the grand jury to vote on an indictment if the prosecution has decided that the case, after presenting the whole case to the grand jury, merits that action. All of those statements are also recorded. They're really, when you walk into a grand jury room, there is nothing that is off the record. From the time that you walk in, you close the door. There is there is some formal recognition that we're on the record. From that point on, everything that the prosecutor says and all the grand jury interactions, questions that the grand juries ask, things like that, they're all recorded. Now, in 35 years, I don't believe that I was ever ordered to turn over those tapes. I know I wasn't. Those tapes of a grand jury proceeding. The only reason why a judge would order that to happen would be if there was some colorable claim that there had been some abuse in the grand jury, because that is the only situation in which the prosecutor's conduct, how they handled themselves, how they handled the case in front of the grand jury would be in play. So the fact that this judge has already, at this very early stage of this proceeding, has already apparently ordered the government to turn over not just the witness transcripts, but actually the tape of the proceedings, suggests to me that there are already conclusions that are in the process of being arrived at, that this prosecution was tainted in the grand jury. And I guess the best way for me to put this is, how could it not have been? When we look at the record, when we look at even just what we know on the public record, we have a prosecutor, as you alluded to, who has never prosecuted a case, has never practiced criminal law, goes into the grand jury on the first or second day on the job, evidently just puts a single witness in, and then secures an indictment. And by the way, does not secure an indictment on certain counts that the grand jury refused to vote out. That kind of slapdash, reckless effort, it is no surprise to me that effort resulted in the potential for there having been abuse in the process, and the judge getting a sense for that is on firm ground in ordering the prosecution to turn these tapes over. And I saw that the prosecutor in court at one point protested and said that for technical reasons it might be difficult to amass this information. Well, in the first place, it was one session of the grand jury. It was one witness. And The whatever the prosecutor said, whatever Lindsey Halligan said, either before, during, or after the testimony was taken, is highly relevant to a claim of grand jury abuse, and it is routine for a prosecutor's office to be able to get their hands on that material expeditiously. There should be no delay here.
Yeah, and let me add a couple of things to Kevin's overview of our grand jury practice. We are not only prosecutors in the grand jury, and just to paint a picture, the only people allowed in the grand jury when the grand jury is in session is the prosecutor, the grand jurors, the grand jury reporter, think court reporter, who is both audio recording everything and, using that little stenography machine to take down every word that everybody says. The only other person allowed in there is the witness who is testifying before the grand jury. There's no judge. There's no defense attorney. There are no interlopers. Nobody. Those are the only people allowed in there. And we're not only the prosecutors in there presenting the case, we are also the legal advisors to the grand jury. What do I mean by that? We will go in, and when we open the grand jury, before we present the first witness, we may give a short modified opening statement. Ladies and gentlemen of the grand jury, let me tell you a little bit about what this case involves. Let me tell you the witnesses you're going to hear from and what they have to say, what I expect they will say in their testimony. Let me tell you about some of the physical evidence you're going to see: crime scene photos, documents, cell phone records, cell site information, forensic testing, for example, DNA results. And then we present all the evidence and all the witnesses. And at the end, we may make a little closing argument. Now, ladies and gentlemen, let me kind of pull it all together for you and explain what we believe the evidence has shown and why we are asking you to vote out to indict particular charges. But then the grand jurors might have a question. Mr. Kirshner, can you explain to us the elements of the crime? Let me use an everyday example in D.C., unfortunately, of first-degree premeditated murder. Yes, I can, and I will break out the jury instructions, and I will read to them what the elements of the crime of first-degree premeditated murder are, and I might go further by saying, let's talk about the evidence that you saw that supports what we're, asserting here, that the evidence supports an indictment for first-degree premeditated murder. We're also the legal advisor, and we have to call it straight, right? So we're still advocates in there. We're legal advisors. We're prosecutors. And I'm going to add my 30 years to Kevin's 35 years. For a combined, 60 plus years, I never once had a judge order me to turn over the grand jury minutes. In other words, what I said to the grand jurors. The only thing we ever turn over is the transcripts of the witness's testimony before the grand jury. So as Kevin points out, this is highly unusual that judges will order the words of the prosecutor as captured on audio tape turned over to the defense because there has been a showing of potential prosecutorial abuse, overreach, misconduct. So, and let me just finish by reading what Judge Curry said in his order yesterday. He said, first of all, Judge Curry had previously said, turn over everything from the grand jury. I'm summarizing and taking liberties there. But the only thing that Lindsey Halligan and the other prosecutors on the case turned over was one transcript from the only witness who testified before the Comey grand jury and some documents. And the court said, well, I've reviewed the transcript and I find it fails to include remarks made by Lindsey Halligan, the indictment signer. So the judge reemphasized, you are directed no later than close of business today, Wednesday, to turn it all over, including the audio tape of whatever Lindsey Halligan, the indictment signer, said in the grand jury. So we will see what gets filed by close of business today. But let me suggest, I don't think we will see it because it will probably be filed under seal for a judge to review privately in his chambers. But I have a feeling next week, when this motion is litigated, there will be arguments about what Lindsey Halligan said made in open court. I'll be in the courtroom covering that for you all, and we'll go live right after it's done to tell you what went on in the courtroom. So that's the first issue. Anything you want to say about Judge Curry's order, or how this is playing out, or how you expect it to play out next week before we move on to what went on today in court?
Well, one word, badly, for the government. That's
Yeah.
actually 4 words, but I think it's important for people to understand just how extraordinary it is that someone would go into a grand jury, a prosecutor would go into a grand jury on their first or second day on the job with no prior training. Um, it's offensive to me, and I know it is to you as well, as a practitioner in this field. It would be akin to somebody believing that they would just be able to take out a wrench and start working on repairing their car without having any prior knowledge about how cars work. So I joined the office. I was not I wasn't allowed into a grand jury for a year. And everyone who joined the office at the same time as I did, we were all in misdemeanors for the first 11 months of our career. And that was the starting off point. And then it was only at that point that we got into by rotating into a different assignment, which was the way that it worked, and it still does work in the U.S. Attorney's Office, as in most prosecutors' offices. It was only then that you were put in a position of going into grand juries and starting to indict minor, low-level cases. And even before doing that, even after 11 months of handling misdemeanor cases, a huge misdemeanor caseload, I had 26 jury trials. But grand jury practice is different even than a jury trial practice. And so I went through another set of training before I did that. And then I tried, and then in terms of the cases that I handled in the grand jury for the first few months in grand jury practice, they were largely simple drug cases, simple robbery cases, things of that nature, felony cases, but not nowhere near on the level of magnitude as a homicide, a violent crime, or the indictment of a former FBI director on charges that are extremely serious and are also very nuanced and complicated. So uh, it's a one thing which I would be very interested in seeing in the tapes of Lindsey Halligan's remarks to the grand jury are the extent to which she goes beyond the factual record that was established by the witness in the grand jury. Prosecutors, anything that a prosecutor is putting before the grand jury and that they're going to be asking the grand jury to vote on has to be something that is developed on the record by way of a witness, either a witness testifying about their own direct knowledge, testifying by way of hearsay, which is permitted in the grand jury, legitimate appropriate hearsay, and on also witnesses sponsoring exhibits, evidence, and describing that evidence. Prosecutors are not allowed to go beyond that, though, and issue their own opinions, for example, as to whether or not a defendant was guilty or not guilty. They're not supposed to go outside the record to talk about other things happening in society. It's verboten for a prosecutor, say, in a jurisdiction that has a high crime rate, to go in front of the grand jury and to in part ask the grand jury to base their action on things that are going on outside the case itself. Um, Talking about the high crime rate, talking about things that the grand jury can do as citizens to battle violent crime by way of their actions. All of that's improper, and I have a feeling, and I think it's a fairly strong instinct that the record as it's established, as these minutes are released to the judge and hopefully to the public eventually by way of a public hearing, it's going to show that there were what's the phrase I'm trying to use, outside the record statements that were made by Lindsey Halligan to press the grand jury to vote this indictment out. And that would be abominable. It would be unethical. It would be improper, but it wouldn't be surprising.
And even on top of that, I mean, listen, we go to law school, we have to learn the rules of evidence. We have to learn the rules of procedure. And it's one thing to know how to try a case. It's another thing to know how to present it to the grand jury. Because as Kevin just mentioned, the rules of evidence don't strictly apply to the grand jury. So, for example, hearsay, which is an out-of-court statement offered in court or in the grand jury to prove the truth of the matter asserted in the statement, that is inadmissible in a court, in a trial, but it's perfectly fine in a grand jury. But that is only one example of the do's and don'ts of grand jury practice. There are constitutional concerns with respect to what information we can put before the grand jury and what information we can't. And those rules operate very differently at trial. I mean, grand jury is a unique animal procedurally. And if you haven't been trained extensively, if you haven't shadowed a, a senior experienced grand jury prosecutor sitting quietly in the corner of the room. Now, remember, a few minutes ago, I said there are only certain people who are permitted to be in the room. As a fellow prosecutor who was shadowing a senior prosecutor, I would be permitted in the room so I could learn how to do a grand jury presentation. And then the first time I would go in, I would have a senior prosecutor looking over my shoulder to make sure I didn't do anything wrong. I mean, there's a very long run up to your first grand jury presentation. And insurance lawyer Lindsey Halligan got thrown in on day one or day two, knowing none of that. So I, for one, can't wait to see the grand jury minutes, because I think they will be spectacular in the worst possible way for Lindsey Halligan. So let's shift over to the brand new development that happened today. So when you're preparing for trial, often there are what are called discovery disputes. So James Comey's attorneys have said, listen, we need all of this evidence and information that was collected up by the prosecutors that we're entitled to under the rules of discovery, because we have a right to investigate whatever it is the prosecutors are alleging James Comey did. We, need to interview potential witnesses. We may need to retain our own expert witnesses if appropriate. And it looks like the prosecutors are falling short on some of their discovery obligations. So apparently there was a hearing today in that federal courthouse in Alexandria. It was presided over by a magistrate judge, not by Judge Nachmanoff, who is the presiding judge in the Eastern District of Virginia case against Comey. Sometimes magistrate judges are kind of low-level judges, and they will take care of some of the minor stuff, discovery disputes and preliminary hearings and things like that. But that brings me to today's reporting, and this is another headline that does not bode well for the prosecution. And today's headline is, Judge in Comey case scolds prosecutors as he orders them to produce records from the probe. In other words, produce the damn discovery you're required to produce under the rules. And I will let you read the money line if you want, if you have it in front of you, Kevin. If not, I'll read it.
I think I'll leave it to you. It is indeed a money line.
Oh, here's the money line from the magistrate judge, whose name is William Fitzpatrick. Judge Fitzpatrick raised his own concerns in the hearing today, telling lawyers, quote, the procedural posture of this case is highly unusual. He said it appears to him that the Justice Department had decided to indict first and investigate later. I thought of the Alice in Wonderland Queen of Hearts saying, sentence first and trial later. So, first of all, have you ever had a federal judge, a local judge, any judge say anything like that to you in all of your decades?
No, and if I had, I would have been honor bound to have gone back to my office and reported that to a supervisor, or if I was a supervisor myself, to report that to the U.S. attorney, because I think that statement in and of itself, if that were, I think in the context that it was made today, it was. It wasn't a firm ruling or a holding by the judge. It was certainly a bit of a preliminary reaction. But if a judge were to take action in a case, in one of my cases, and use that phrase, that would be something that I would have to report back to my office. It would have ethical consequences. There is really no more damning thing you can say about a prosecutor than that they indicted someone. In other words, brought a formal charge against them without having first investigated the case, meaning not just investigate with the purpose of developing evidence that supported an indictment, but also investigating whether or not there was evidence that did not support it did not support an indictment or undermined an indictment. In other words, what's called Brady evidence, exculpatory evidence, evidence that would tend to show that the defendant was not guilty of charges. And you only get to that evidence if you investigate. You don't indict first and then investigate second. The other thing that I just want to point out, and you're very familiar with this as well, Glenn, and that is that the Eastern District of Virginia is not a jurisdiction that is known for having judges who are anti-law enforcement. It is a when we were when I was trying cases, I would hear about jury verdicts that were coming out of the Eastern District of Virginia, and I was sometimes envious about what it would be like to try cases in that jurisdiction, because the demographics are just completely different than they are in a big city. Big cities, including Washington D.C., include judges and juries who tend to be more law enforcement skeptical. The jurisdiction, the Northern Virginia jurisdiction, and in fact the entire state of the entire Commonwealth of Virginia, tends to be less populated by folks that have those inclinations. The Northern Virginia area, for example, is still very much there. There's a lot of military presence throughout the state of Virginia, even though it's a purple state, and even though it went solidly Democratic last night. It is not a liberal left wing jurisdiction that is filled with judges who are bent on going after prosecutors and their law licenses, and going after cops and finding that they're not credible. So the fact that this prosecution is already slipping on banana peels in the Eastern District of Virginia, in that jurisdiction, shows that, in fact, and I'm not. Look, I was a prosecutor for 35 years. I took my lumps every so often. I had juries come back not guilty. I had evidence that was suppressed on occasion by judges, but I always respected the judges in D.C., and I respected the juries in D.C. But my point is just that these are not. I would imagine that these judges are not judges who came into this assignment looking for ways to undermine prosecutors and undermine law enforcement.
No, I think these judges expect competence. They expect candor. They expect prosecutors in particular and defense counsel to abide by the rules of the court, the rules of procedure, the rules of discovery, any court orders that are issued with respect to the schedule set out for providing discovery to the other side. And I'll tell you, we already have multiple judges in the Comey case alone criticizing these prosecutors from North Carolina in ways that I have never heard judges criticize prosecutors. And so that does not bode well for the Comey prosecution, the likelihood of success on the merits, because I think things are very quickly going to go from very bad to much worse. And that is as it should be, given what we know about the history of Donald Trump's, announced revenge that he was seeking against both James Comey and Letitia James. Why? Because James Comey was a very vocal critic of Donald Trump's lawlessness, and Letitia James, as the New York Attorney General, brought a civil suit that was successful and exposed and held Donald Trump accountable for massive, systemic, years-long business fraud. And people might say, well, didn't some of that get busted on appeal? Not the finding that he engaged in massive, systemic, years-long business fraud, only the amount that was ordered to be paid, roughly half a billion dollars. It looks like that amount will be reduced somewhat when the case is sent back to the trial court. But the finding of what Donald Trump did holds. So, of course, he wanted to retaliate against Letitia James. So if these cases end up, falling apart spectacularly, that is as it should be. And that will be an indication of the criminal justice system, at least writ large, working as it should. Right now, the Department of Justice, the executive branch, is not working as it should, but hopefully we'll come out the other end of this and the rule of law will come back into the light of day. So what?
Just for a second here, and because we've talked a lot about how this case was put before the grand jury in one day, and what the ramifications of that can be in terms of what the grand jury heard and what the grand jury didn't hear. To put that in perspective, just how ludicrous that practice was, think about what this case against James Comey entails. He testified before Congress, and I'm not going to get deep in the weeds, but he testified before Congress, and he was asked about whether or not he had authorized one of his subordinates, someone named Andrew McCabe, to leak information to a law professor. So this was one question and answer that was part of a lengthy hearing. The subject matter of the hearing would be something that would at least have to be summarized to the grand jury, if not the entire hearing played for the grand jury, so the grand jury would be able to see this question and answer in context. So that's number one. Number two is that we know from the public statements of Andrew McCabe that he, in fact, said that Mr. Comey did not authorize him to make this leak in advance. He has made public statements about that. He was the subject of an internal investigation within the Department of Justice about that matter. Mr. McCabe has said that he was never called down to the grand jury to be asked about this. And so it's highly unlikely that Mr. McCabe's statement was actually introduced to the grand jury as well. And if it had been, that would have been an entirely different set and more complicated set of facts that would have to have been brought to the grand jury's attention. The idea, and then we have on top of that now, it's come out that a part of the evidence that is in the case was evidence that was seized from cell devices and other or electronic devices of the person who is alleged to have received leaked information, that being a law professor. And there are now questions being asked as to whether or not those materials may have been privileged and whether they may have been improperly put before the grand jury. It shows you just my little encapsulation, which took about 45 seconds, shows you just how complicated this matter is, how nuanced it is, and how really significant it is that a grand jury was asked on the basis of the skimpiest possible record to indict someone on any felony, let alone a serious felony such as the charges posed here.
Yeah, and the judges, plural, have put the prosecutors on a very short leash because with respect to Lindsey Halligan's comments to the grand jury that are on audio recordings, the judge gave them until close of business today to submit them to the court. And in this new discovery dispute over whether there's some evidence that was obtained from some search warrants back in 2019 and 2020, the judge said, yeah, the defense is entitled to those. I need you, I'm ordering you to turn them over to James Comey's defense attorneys by close of business tomorrow. So, they're on a very short leash, a very short timetable, and I really do feel like things are going to go from bad to worse. So I'm looking forward to attending the hearing next week on the 13th, seeing how this litigation begins to play out. And then, Kevin, I'm sure you and I will be jumping back on here for another discussion of the prosecutor's verdict. So if you had to choose a word or a phrase to describe by way of a mock verdict, what in the world we're seeing in this case, what would you choose?
I don't even know if I can encapsulate it in just a phrase. I really can't. I think that if I might render a verdict as to the status of Lindsey Halligan's bar license, which I would say is on shaky footing. That's the best phrase I can come up with. And I don't say that with any sense of malice, and I don't say that with any sense of satisfaction. People make choices in life. She could have turned this job down. She could have decided that she was not going to do this and she wasn't going to take the actions that she did. But she was a setup. She was a dupe. She was a fall guy in all of this. But she made her own choices, and so she's going to be suffering. I anticipate, and I don't say this with any satisfaction, but I anticipate that she and anyone else who was involved in this odious prosecution are going to face consequences on the back end for what they've done. So that's my verdict.
As well they should. And I think my verdict would be that they're exhibiting like cavalier incompetence at a minimum. That is not going to nefariousness, because what we know is that they are playing to an audience of one, dear leader, Donald Trump, and the sort of cavalier incompetence with which they are fumbling forward is just staggering to people who really and I can speak for you, revered not just the grand jury practice, but revered the prosecutorial practice and the responsibility and the honor we had to represent, not legally, but actually the victims of crime, the community, the rule of law, the Constitution. I mean, we made sure we closely guarded and protected the constitutional rights of every target of a grand jury investigation, of every defendant we prosecuted, because that was our sworn obligation as well. It's not just, let's get notches on our belt, make sure we win convictions across the board. No, it's let's make sure we do right by the rule of law, the Constitution. And that means doing right by the victims, doing right by the community, and doing right by the defendants that we pursued. So, we had a reference for this. And, I'm seeing the exact opposite out of these people, Lindsey, Halligan, and these prosecutors.
I as well, and you stated that very well. I still miss that job every day. I left to sort of embark on another venture, but up until November 5th of last year, I was still contemplating going back, and I knew as of November 5th that I wouldn't have them and they wouldn't have me. But and that's sad. But if I were I've had a lot of opportunities over the last 2.5 years to think about what I miss about the job, and I think the thing I mean, there are certain parts of life that replicate to some extent the trial experience. You can't really. I mean, I miss the grand jury practice itself as much as anything, if not more. Just the interaction you had with everyday folks who come in. They're asked to sort of give up their lives for 6 weeks to 2 months. In federal grand juries, it's even longer. But they are there to serve, and the interactions that I had with grand jurors over the years, they were always beneficial. And I think I've said this on the show before, but they come in at 23 at a time, and I would tell young prosecutors, you have 23 people in the community from the community who are coming into our building, and I want those 23 people, to leave with a better sense of law enforcement, of the criminal justice system than they had when they came in. So I wanted them to learn from me, but I always learned much more from them. And it was like I revered the practice, just like in the phrase that you just used.
Yeah. All right, Kevin, thank you for jumping on. We'll do it again, I'm sure, soon. Thank you, everybody, for joining us, and I will see you a little bit later at tonight's community meeting. Bye, all.
Thanks now.